Your Honour, 106 charges have been laid against my client. My client is a 16-year-old Torres Strait Islander boy. On the date of his arrest, he was charged by police and questioned at the scene, and before he was taken to a police station for further questioning, he was put into the back of an unmarked police vehicle and driven around a residential area by the arresting officers. One of those officers, Your Honour, sat in the back of the vehicle with my client, pointing out to houses that had been the victims of recent robberies. That officer asked leading questions of my client, such as, "That house over there had a bike stolen from it last week. Bet that was you, wasn't it?" While my client sometimes replied that he didn't remember, for the most part, he agreed with the officer's suggestions. Now, Your Honour, you'll be well aware that this line of questioning often leads, especially for young Indigenous people, to admissions that have come about as the product of a thing called gratuitous concurrence. Now, admissions of this sort do not hold great evidentiary weight, and it is exactly to prevent such evidence from being relied upon in criminal proceedings that the strict provisions in the Police Powers and Responsibilities Act and Code were enacted. This, Your Honour, brings me to my first point. Chapter 15 of the Police Powers and Responsibilities Act establishes the rights of persons that are being questioned for indictable offences and the corresponding duties of arresting police officers. Your Honour, my client was questioned at the scene of the arrest, in the back of the unmarked police vehicle, and again later that same day at the police station. The evidence relied upon by the Crown in this case comprises of a written record of admission, taken from the admissions allegedly made by my client at the scene of arrest and in the vehicle, and a record of interview taken from the questioning that was undertaken at the station. As Your Honour will see reproduced on page 4 of my written submissions, Section 436, subsection 2 of the Act provides that an officer must electronically record any admission where it is practicable to do so. Now, the Act also provides a number of example scenarios where it would be impracticable for an officer to record an admission. And while Your Honour can find these also reproduced in my written submissions, I can assure you now, on the record, that the circumstances provided in those examples are in a league of their own compared to the circumstances in this case. My client was in police custody, submissive to those officers' authorities, which is clearly demonstrated, Your Honour, by the incident of gratuitous concurrence that happened during the questioning, and there was, by no stretch of the imagination, any pressing circumstances that would have prevented an officer from pulling out a recording device and having my client provide his admissions on the record. Your Honour, my client was in police custody and very clearly submissive to those officers' authorities, as is demonstrated by the incident of gratuitous concurrence. And further to that, there is by no stretch of the imagination any pressing circumstances that could either have necessitated or excused the officer's flagrant disregard for the strict requirements set out in Section 436. Setting aside the officer's failure to record the initial questioning, I seek to turn Your Honour's attention to the written record of admission that has been adduced against my client. Your Honour, that record of admission, was produced 3 months after my client's arrest, and at no point during the intervening time has my client been afforded the opportunity to read that statement or offer corrections to any errors that might have been produced in it, as required by Section 437 of the Act. Section 436, subsection 3 provides that an admission made by my client will only be admissible in evidence if it has been electronically recorded as required by Section 436 of the Act, or it is contained in a written record of admission that has been produced following the process provided for in Section 437 of the Act. Your Honour, I can assure you that neither of those processes were followed by the officers in this case, and I therefore plead that there is a prescribed ground upon which the court can exercise its discretion, and in fact should exercise its discretion, to set aside the written record of admission in this case. Your Honour, I now wish to move to my second argument. Chapter 15, Part 3 of the Act provides a range of measures intended to safeguard fairness and the rights of persons questioned for indictable offences. All persons questioned by police as suspects for an indictable offence are provided with the opportunity to talk to a support person, a friend, a relative, a lawyer. Now, Your Honour, the legal system recognises the particular vulnerabilities experienced by children and Indigenous Australians within the criminal justice system, and therefore provides some additional protections. Section 421 applies when an officer reasonably suspects they are dealing with a child, of which there can be no doubt in this case, Your Honour, whether officers asked my client what age he was when he was arrested. Subsection 2 provides that an officer must not question a child until that child has had a chance to speak to a support person, and this is the critical bit, if I may draw Your Honour's attention to it on page 5 of my written submissions. A support person that the child has had the opportunity to choose and speak to in circumstances where they cannot be overheard. Now, the police failed to give my client that choice. And in fact, they failed to contact his parents at any point during his arrest. They instead, upon arrival at the station, introduced him to an unknown support person and gave him some minutes with that person before the interview began. Your Honour, my client has instructed me that during those minutes, the support person told him something to the effect of, just tell the truth and answer the officer's questions. Your Honour, the prejudicial effect of this failure by the police to provide my client with his legal rights can perhaps only have been made worse by the breach of the last duty which I will raise before the court. Section 26 of the Responsibilities Code, contained in Schedule 9 of the Police Powers and Responsibilities Regulations, contains a simple duty that a police officer, when questioning a person about an indictable offence, must caution them about their right to remain silent, and where that person is Aboriginal or Torres Strait Islander person, the officer must take special care to ensure that the person understands that caution. Now, Your Honour, observing this duty is a fundamental step that must be taken by an officer to ensure that any admission that is made voluntarily and will therefore be admissible in evidence. At no point was my client advised of his right to remain silent. Not when he was arrested, not when he was driven around in the back of that police vehicle, and not when he was finally taken to a station and sat down for the interview. Now, it can come as no surprise perhaps to the court in these circumstances that when my client was sat down for that interview and questioned, he made full admissions to the 106 charges laid against him. Your Honour, I submit that the officer's failure to observe Section 26 of the Responsibilities Code has critically affected the admissibility of the record of interview. My client's admission that is contained within that record was unlawfully and unfairly obtained, and it should therefore be excluded on the basis of the Bunny and Cross discretion. In summary, Your Honour, I plead that there have been several gross breaches of important provisions contained in the Police Powers and Responsibilities Act and Code in relation to both the written record of admission and the record of interview that the Crown seeks to rely upon in this case. The denial of fundamental rights and legal protections, especially for a vulnerable juvenile like my client, is a strong basis upon which the court can exercise its discretion. I therefore plead with Your Honour to set aside the evidence that has been relied upon by the court in this case. It is a simple matter of justice. Your Honour,